Welcome. My name is Shannon Bryant, Traffic Safety Resource Prosecutor for the state of Nevada. This is part of the TSRP training video series intended for Nevada law enforcement conducting DUI traffic stops. These short training videos are intended to refresh training for in-service officers who have already completed their Category 1 training. This brief training is on warrantless blood draws from an unconscious DUI suspect and is designed to help you identify when and why you, as the law enforcement officer, should pursue a warrantless blood draw from a DUI suspect. We do have some ground to cover here, so let's get started. We first need to look to the statutes for our authority to take action. If you are a law enforcement officer in Nevada, you've heard of implied consent, and you were instructed at the academy level on how NRS 484C-160 requires you to read the implied consent warning to suspects after an arrest. But there's more to this statute. For example, subsection 9 gives you the authority to apply for a warrant or a court order to use reasonable force to obtain a blood draw if your suspect does not consent to the draw. Doing so protects the suspect's Fourth Amendment rights as well as the integrity of your DUI investigation. A warrant is normally required for an evidentiary blood draw if a suspect does not consent. That is, normally. There may be circumstances, however, where you are permitted as the law enforcement officer to direct that an evidentiary blood draw be performed even without a warrant. Under subsection 3 of 484C-160, if the person to be tested is dead or unconscious, the law enforcement officer shall direct that the samples of blood be tested. Note that the language here, shall direct, is mandatory. It makes it clear that the law enforcement officer is not just permitted to order the blood draw, but is required to. And also note that the person conducting the draw is directed to perform the draw, not requested. Fortunately, on this point, we do have some guidance from the U.S. Supreme Court. In 2019, the U.S. Supreme Court issued an opinion in Mitchell versus Wisconsin. In Mitchell, the court looked at a state statute similar to Nevada's that authorized blood draws from an unconscious DUI suspect. In the opinion, the court emphasized that impaired drivers present a significant threat to public safety. And the court noted that important evidence of the crime of impaired driving dissipates quickly from the blood. In most cases, and citing its own 2012 Missouri versus McNeely opinion, the court noted there is sufficient time for the law enforcement officer to apply for and obtain a search warrant. Because metabolization of alcohol alone does not create an exigency to justify not seeking a warrant. However, the court did note that there are circumstances where applying for a warrant is not required. Justice Alito, the author of the plurality opinion in Mitchell, stated that a person rendered unconscious creates a medical emergency, and that even with technological advancements that make warrant applications faster, such as telephonic or electronic warrants, there may be terrible collateral costs associated with even a brief delay. Therefore, the court held that there are 4 factors that must be present to justify a warrantless evidentiary blood draw from an unconscious person. 1. The law enforcement officer must have probable cause to believe that the suspect committed the DUI offense. 2. The suspect's state of unconsciousness or stupor requires immediate medical transport and/or treatment. 3. The suspect's blood will be drawn anyway by medical personnel, such as for diagnostic purposes. And 4. The officer reasonably judges that applying for a warrant will take him or her away from other pressing needs or duties related to the crash or incident. What exactly constitutes pressing needs or duties was left somewhat vague, but the court did give us some examples as guidance. Such needs or duties might include securing medical care for the suspect or others involved in the crash or incident, or the time needed to deal with fatalities, or the time needed to collect, photograph, and preserve evidence in the investigation, or even conduct traffic-related duties such as directing or redirecting vehicles or to warn other drivers of roadway hazards as a result of the crash or incident. The key takeaways from the Mitchell opinion in conjunction with Nevada law are: law enforcement officers can and should direct a hospital phlebotomist to collect a warrantless evidentiary blood draw when the law enforcement officer has probable cause that the suspect committed the DUI offense, the suspect is unconscious or incoherent, the suspect requires immediate medical transportation and/or treatment, the suspect's blood is going to be drawn anyway by medical personnel, and the law enforcement officer reasonably believes that the time spent applying for a warrant would otherwise be spent doing other needed duties related to the crash or incident. Now, it is worth noting here that Justice Alito did not discuss series blood draws in alcohol-only DUIs, where we would need that series to show a retrograde BAC analysis. Applying the principles in Mitchell, however, it is logical that the law enforcement officer can still direct an initial warrantless evidentiary blood draw, but because of the inherent delay between draws in a series draw, that officer should then apply for a warrant as soon as possible after that first draw to use that time between the draws wisely. This concludes this training video. My name is Shannon Bryant, your Traffic Safety Resource Prosecutor. On behalf of the National Highway Traffic Safety Administration, Nevada's Office of Traffic Safety, and the Washoe County District Attorney's Office, thank you for all you do and for keeping Nevada's roadways safe.